the first thing I did was determine that we needed to get the facts. We needed to determine what had happened and who was culpable in a civil and criminal sense. And to that end, I asked Paul Weir to serve as a Special Assistant Attorney General to undertake and continue the grand jury investigation around the ceiling tunnel collapse and potential manslaughter investigations. His mandate was merely that, to determine the facts. We moved into phase 2, which was, now that we believe we know what happened, what sort of culpability and responsibility can we proceed as a matter of fact and matter of law? And Paul continued to serve with staff in our office on those issues. We believed, and I will say this today, we believed we had sufficient evidence to indict Bechtel, to indict Parsons Brinckerhoff, and to indict them as they are a joint venture, and Powers. Powers, the company that made the epoxy, as you know. You also know that in August of 2007, a grand jury returned indictments of 1 count of manslaughter against Powers. That case is pending, and I am limited in what I can say about that case, but I do want to note that when all 3 companies were told this by us, that we believed we had sufficient evidence to indict, Bechtel and Parsons immediately, and I would argue in a very sincere and eager effort, said, what can we do? And we then began to determine whether there was a way, short of proceeding in a criminal charge, to reach a resolution that would be sufficient. What I will say is that we believe that as a factual matter, the culpability of Bechtel and Parsons was different in kind from the actions and omissions of Powers, and their willingness to acknowledge certain responsibility and take on what is ended in today's agreement, I believe, was in the best interest of the Commonwealth, and in fact served better, ironically, the purposes of the criminal justice system than had we proceeded with indictments. And let me explain that. Typically, in order to accomplish justice in the criminal justice field, we look at a determination of admissions. We look at what's appropriate restitution and punishment. We look at rehabilitation, and we look at specific and general deterrence. When we looked at what we could do in Massachusetts with manslaughter charges and realized that the only penalty a corporation faces in this Commonwealth is a $1,000 fine, it was pretty simple for us to determine that with a willing defendant, potential defendant, it would be far better to pursue other avenues and seek resolutions that would include the kinds of agreements that we present today. And let me just be specific about that. The amount of money that has been paid and will be paid over the next several days and months as a means of punishment and restitution to the Commonwealth for the flaws in this system far outweigh what we could have accomplished, certainly in a criminal indictment, and perhaps even in a complicated, long-ending, and endless appeals in a civil matter. And so that, we thought, was in the best interest of the Commonwealth. We believe that the catastrophic reopener that U.S. Attorney Michael Sullivan referred to provides a safety valve for the Commonwealth should another event like the ceiling tunnel collapse occur. And we are not prohibited should that happen. We hope it will not. We are keeping our fingers crossed that it will not, but there have been so many issues with this tunnel, and there are contingencies known and unknown, that we believed it was important to provide the catastrophic reopener in terms of protecting the Commonwealth. We looked at the project safety review and the compliance agreements that also fit into what we might do if we charged a person criminally. What are the guarantees that they will change their corporate culture? What are the guarantees that they will hopefully mitigate the risk that something like this will happen again? All of these fit in very well, we thought, with what we would like to accomplish, something we could not have done simply by indictment. And I know the question will come up and it's been under discussion, we considered the issue of debarment. Let me say that debarment is a tool that is available to the government. In some instances, it is not always finely tuned, and it does not always answer the questions that we want. I will say that there were members of the legislature who spoke forcefully about it, and I believe that that was helpful to us in light of the governor's concerns and the legislature's concerns to accomplish the kind of agreement that we got today. But we do believe that we accomplished much more sufficiently, adequately, and fully what we could not have done simply by debarment in this instance. We believe that I want to be clear that when I met this summer with Angel Devalier and the husband of Melena and his daughter, her daughter Raquel, I was very touched by the sadness of their loss for their mother. But also what came through in that meeting was the incredible love that they had felt for her and the warm memories they had. And I was incredibly impressed by their need to feel that something would change, that this would not happen again. They knew we could not bring his wife, her mother, back, but they stressed then, and they stressed as we talked to them this morning about this agreement, the need to feel that some changes would occur and no family would have to go through this again. That desire on my part has driven much of what we have done in terms of structuring this settlement today, in terms of other action we have taken, but also in terms of this structure. And as we explained it to them, and our hope that it would resolve this and provide for specific and general deterrence, not just for these companies, but others that might pursue these projects, we will hope that will be successful. If you look at the Big Dig today, and whether you look at the Zachem Bridge at dusk or at early morning, when you realize there is increased efficiency for traffic in and out of Boston, and particularly when you look at the beautification of the Greenway that used to be covered by the rusting overpasses that are now gone, we can well ask whether this was a good bargain. We can well ask, and we will be doing that into the future, whether we got what we paid for. We know that this was a long, expensive, and costly product. I do not have that answer for you today, and we may never get it. But we do know that we had a set of problems facing us. We needed to reach a resolution, and we put forward our best efforts as lawyers, as policymakers, to say this is what we can do this reasonably well, and we can do it reasonably quickly. And we can build in, as we did, the monies that we believe will be there for whatever extraordinary or non-routine maintenance that the flaws in this tunnel and building project will require going forward, so that taxpayers will not be burdened by future costs. We believe that we have provided the safety valve should something else catastrophic occur, but we do not have a crystal ball. That was the best that we believe we could humanly have done. And we believe and we hope that we have accomplished something that means that no other family will have to go through what the family of Melena Del Valle has gone through with this. And so for that, I think that we will see that this is good to have this resolve to move forward and hopefully accomplish most of the goals that we sought to do. I'm going to turn the microphone over now to Ted Doherty, who is to my right, who has been intricately involved with this project.
Thank you, Martha. You know, as both Martha and Mike mentioned, this is an extraordinary result for the taxpayers of Massachusetts and the taxpayers of the federal government. I'd like to commend the work of the agents within the Office of Inspector General who worked so tirelessly on all these investigations, and the rest of our Big Dig law enforcement colleagues, especially members of the United States Attorney's Office and the Massachusetts Attorney General. Thanks very much.
And Special Agent in Charge Warren Bedford.
Thank you, Martha. I also would like to acknowledge the collaboration by all the agencies you see represented here on the podium. The Big Dig Task Force was established to specifically look at the patterns and practices of the contractors and suppliers to the Big Dig. This effort brought together the resources of state and federal agencies which aggressively pursued this complex matter. Today's settlement represents a significant accomplishment. The American public has a right to demand accountability. The American public has a right to travel safely on its highways. And today's events once again demonstrate that those who commit fraud and abuse against government programs will be aggressively investigated. Thank you.
We should note that the full text of this agreement, as well as the agreed upon facts, and I will tell you that the ink was still drying as we came up here to do this, because we've just literally signed off on this, should be available sooner rather than later, but certainly within a few hours. We want to get that posted. We both agreed and wanted to be transparent on this, and so we're happy to take questions and answer what we can.